Your green card case could be destroyed right now, and you would not even know it, not by a lawyer's mistake, not by USCIS, by you. By one wrong move, one missing document, one assumption you made because someone in your community told you something that was true 3 years ago, but is dead wrong today. And here is the most dangerous part. The people who lose their green card cases in 2026 are not careless people. They are people exactly like you, educated, hard-working, people who followed the process for years, paid thousands of dollars, waited patiently, and then made one avoidable mistake that erased everything. So if your green card matters to you, do not skip a single second of this video, because what we are about to reveal could be the difference between a green card in your hand and a deportation order with your name on it. Welcome to Global Immigration News. I am going to give you the 5 most dangerous green card mistakes of 2026. The real ones, the ones immigration attorneys see destroying cases right now, and I am going to tell you exactly how to protect yourself. Stay until the end, because the 5th mistake is the one nobody talks about, and it is quietly killing more green card cases than all the other 4 combined. Let us start with mistake number 1. And this one hits hard, because it happens to people who think they are doing everything right. You are in the middle of your green card process. Your petition is filed, maybe your I-485 is pending, and then life happens. Your H-1B is expiring. Your employer is talking about a layoff, your family needs you back home, and you need to travel internationally. And someone tells you, do not worry, your application is pending, you are protected. So you make the move, you travel, you change jobs, you let your visa lapse, and months later, USCIS comes back with a decision that stops your heart. Because here is what that person did not tell you. Having a pending application does not automatically protect you from every immigration consequence. It does not. If you leave the United States while your I-485 is pending and you do not have a valid advance parole document, USCIS can treat your departure as an abandonment of your entire application. Not a delay, not a complication, an abandonment. Years of waiting, thousands of dollars in fees, and the moment that plane takes off without the right document in your hand, it can be over. This is not a rare edge case. This is happening to real applicants in 2026, people who were one document away from safety and did not know it. The protection is real, but it requires action on your part. You need to apply for advance parole before you travel. You need to verify that your travel window, your document validity, and your case status align before you purchase a single flight ticket. And if your visa is expiring, or your employment situation is changing during the green card process, you need to talk to an immigration attorney before you make that move. Not after, before, because after is too late. Now mistake number 2, and this one is about paperwork, but not in the way most people think. Most applicants know they need documents. They gather their birth certificate, their passport, their tax returns, their marriage certificate. They put together a thick folder and they feel prepared. But here is what they do not realize. USCIS is not just checking whether your documents exist. They are checking whether your documents tell a consistent, believable story. And if even one piece of that story does not match, the entire case becomes suspicious. In family-based green card cases, USCIS officers in 2026 are looking at your marriage under a microscope. They want to see joint bank accounts, shared lease agreements, photos across multiple years, evidence of shared holidays, shared decisions, shared financial obligations. They want proof that 2 people actually built a life together, not just a relationship that looks real on paper. When couples submit the minimum required documents and assume that is sufficient, they get called in for an interview. And at that interview, an officer who has already decided your case looks thin will ask both of you detailed, probing questions separately. And if your answers do not align perfectly, you are looking at a fraud finding that follows you permanently. In employment-based cases, the problem is different but equally dangerous. The job described in your original labor certification or your I-140 petition must match the job you are actually performing. If your title changed, if your duties evolved significantly, if the company reorganized and your role shifted, and none of that was properly documented and disclosed, you have a consistency problem. And USCIS has become extremely skilled at identifying these gaps. Their officers are trained to cross-reference your petition documents against LinkedIn profiles, company websites, tax records, and W-2 forms. Inconsistency is not something you can explain away at an interview. It is something you need to prevent from entering your case in the first place. The solution is not simply gathering more documents, it is building a case file where every single piece of evidence supports every other piece, where the story told by your I-130 is confirmed by your financial records, where the job described in your I-140 is confirmed by your employment verification letter, where your marriage story told in your photos is confirmed by your shared utility bills. Completeness and consistency, together. That is what wins green card cases in 2026. Mistake number 3 is the one that confuses even intelligent, well-informed applicants, and it involves the Visa Bulletin. Every single month, the US Department of State releases the Visa Bulletin. This document controls when applicants in certain green card categories can file their I-485 or have their case finalized. It has 2 charts, final action dates and dates for filing, and navigating these charts incorrectly can cost you months or years of progress. Many applicants in the EB2 and EB3 categories, particularly those born in India and China, are living inside a priority date queue that stretches back more than a decade. For these individuals, the Visa Bulletin is not background information. It is life-defining data that should be reviewed every single month without exception. Here is what goes wrong. Some applicants file their I-485 before their priority date is actually current because they misread which chart applies, or they did not verify whether USCIS had accepted the dates for filing chart for that particular month. Their application gets rejected and returned. They lose filing fees. They lose time. Others are in the opposite situation. Their date becomes current, a rare favorable window opens, and they do not act because nobody told them to check the bulletin that month. That window closes, the date retrogresses, and they are back to waiting, sometimes for years. In 2026, priority date movement has been unpredictable. Dates that advanced significantly in previous years have retrogressed without warning. Applicants who made housing decisions, career decisions, and family decisions based on an expected approval timeline have been blindsided by these movements. The only way to protect yourself is to treat the Visa Bulletin as required monthly reading, and to understand not just where your date stands today, but what movement in your category historically looks like, so you can plan with realistic expectations. Mistake number 4 is one of the most emotionally understandable mistakes on this list, and that is exactly what makes it so dangerous. After years of waiting, paying, documenting, and hoping, applicants start planning around an anticipated green card approval. They sign long-term leases. They make significant financial commitments. They change employers, assuming that portability rules protect them. They bring family members to the United States based on expected timelines. And then something changes in their case. A request for evidence, an interview notice, a policy shift. And suddenly, the foundation of all those plans is unstable. The specific scenario we see causing the most damage in 2026 involves job portability. Under Section 204J of the Immigration and Nationality Act, certain employment-based applicants can change employers after their I-485 has been pending for a specific period, as long as the new position is in the same or a similar occupational classification as the original petition. This is a genuine and valuable protection, but it has requirements that must be carefully verified and documented. We have seen applicants change jobs confidently, believing they are protected by portability, only to discover at the adjudication stage that their new position does not qualify, because the occupational classification was not sufficiently similar, or because the portability was never formally documented in the case record. If you are considering a job change during your green card process, you need a portability analysis from a qualified immigration attorney before you make that move. Not a quick opinion from a colleague who changed jobs and it worked out fine. A professional, documented legal analysis specific to your case and your new position. The stakes are simply too high to rely on anything less. And one more dimension of this mistake that often goes unmentioned: family-based petition complications. When a US citizen or permanent resident petitioner dies, divorces, or experiences a dramatic drop in income, While a beneficiary's case is still pending, there are specific legal protections available under current USCIS regulations, but those protections are not automatic. They require action, they require documentation, and they require awareness that the protection exists in the first place. If you are in a family-based case and your petitioner's circumstances change, do not assume the case is automatically lost. Seek qualified guidance immediately, because there may be more options available to you than you realize. Now we arrive at mistake number 5, the silent case killer, the one that runs underneath every other mistake on this list and makes all of them worse. In 2026, the single most destructive force in immigration cases is not complicated law or long wait times or hostile policy. It is wrong information acted upon with confidence. Everywhere in immigrant communities, in WhatsApp groups, in Facebook forums, in family dinner conversations, in online comment sections, immigration advice circulates freely and is passed from person to person as if it were verified fact. And the people sharing this information are almost always genuinely trying to help. The problem is not bad intentions. The problem is that immigration law is fact-specific, category-specific, country-specific, and constantly changing, and informal advice, by definition, cannot account for any of that. Here is the reality you need to internalize. An immigration rule that applied perfectly to your cousin's spouse from Mexico in 2022 may be completely inapplicable to your employment-based case as a national of India in 2026. A processing time someone experienced at one USCIS field office tells you nothing reliable about what you will experience at a different office. A policy that was in effect 18 months ago may have been reversed, updated, or reinterpreted by a court decision you never heard about. Acting on outdated or incorrect information in immigration is not like acting on outdated information in other areas of life. The consequences are measured in years and sometimes in permanent bars to admission. In 2026, the volume of immigration content online has exploded, but volume is not quality, and confident delivery is not accuracy. The most dangerous advice is the advice that sounds authoritative, comes from someone who successfully navigated their own case and addresses your situation, but gets one critical detail wrong. That one wrong detail, applied to your specific circumstances, can be the difference between approval and denial. Protect yourself with 3 habits. First, use official sources as your foundation. USCIS.gov, travel.state.gov, and the monthly Visa Bulletin are your primary references for all factual immigration information. Second, for any significant decision during your green card process, get professional legal guidance from a licensed U.S. immigration attorney, not a notario, not a consultant, not a family friend who happens to work at a law firm in a different capacity. A licensed attorney who practices immigration law and who has reviewed your specific case. Third, stay connected to immigration information channels that are current, responsible, and clear. If this channel is giving you real value, then you already know what to do. Subscribe to Global Immigration News right now if you have not already. Hit the notification bell so you never miss a critical update. We are committed to bringing you accurate, timely, and clearly explained immigration information every single week. Visa Bulletin breakdowns, USCIS policy changes, processing time updates, and everything else that affects your immigration journey in 2026. You deserve information you can trust, and that is exactly what we are here to provide. Also, join our WhatsApp channel. We post immigration alerts, breaking updates, and important policy notices between videos, so you stay informed even when things move fast. The link is in the description below. Here is what you need to carry with you after this video. Protect your lawful status at every stage of the green card process, before any international travel, before any job change, before any major life decision. Verify the immigration consequences first. Build a case file that is not just complete, but internally consistent. Every document must support every other document, with no gaps and no contradictions. Monitor the Visa Bulletin every single month. Understand which chart applies to your situation and act during favorable windows before they close. Do not make irreversible life decisions based on anticipated approval. And if you are considering a job change, Confirm portability qualification with a qualified attorney before you move. And most critically of all, stop trusting immigration advice that comes without credentials, without knowledge of your specific case, and without currency in today's rapidly evolving legal environment. Your green card represents your future. Protect it like it. We will see you in the next video.